Shalom, shalom, everybody. So I'm going to go ahead and get this webinar started. If you are coming into the room, please be respectful and put yourselves on mute. All right, so as people are coming in, please put yourselves on mute so that we can get a clear understanding of everything that we are going on. All right, if it is people you would that's having some issues logging in, they shouldn't if they're already a mentee because you're just signing into your class. Okay, now it's 6 minutes after. I have a lot of things to cover in this webinar. All right, so and then I have to give you some guidelines on where to get the templates and everything. But I want to say welcome to La Maximum Foundation Trust Webinar for 2019, hosted by yours truly, Tiffany Gabrielle Israel. Okay, in this webinar, we are going to be discussing topics such as the definitions of trust in the state, funding a trust, your state code on method of creating a trust, per your state, as I said, handwritten self-proving will, inter vivos trust, joint marital trust, certification of trust, declaration of trust deed, appointment of trustee, employee identification number / TIN of trust, power of attorney, private security agreement, commercial security agreement, property attachment, indemnity agreement, and hold harmless, and trust structure. How we're going to put all this together. All right. Now, it's going to be a bit reading on my side. I'm going to blow this up for you guys. Please, I'm going to say this before I start. If you are on the mobile app, I sent an email out for everybody on instructions, okay? If you are using your phone to come into this app and you cannot see my screen, if any of you cannot see my screen before I continue, in the chat line, in the chat box, let me know, and then I will give it a few seconds, okay? If you cannot see my screen, okay, Stacy, can everyone else hear me? I'm about to take y'all off mute really quick. Can everybody hear me?
Hear you.
Perfect. All right.
Yes.
All right, now before I take y'all off mute, let's make sure.
Yeah.
Is there anybody in here that cannot see my screen? If you cannot see my screen, say, I cannot see your screen, Tiffany. Perfect. So, all right. I sent out the instructions. If you cannot see the screen, that means that you are on the phone and you need to enter in via internet, okay? So I take it that everybody is in here and we are ready to go. All right, to start it off, we need to get some clarity as to exactly defining the trust, all right? In order to get into contract law and trust law, you first have to understand, let me put everybody on mute, sorry. All right, there we go. In order for you to understand contract law, trust law, any other kind of terms, or whatever agencies, you have to know the defining and the lingo in which it goes by. Okay, so anytime you're embarking on a new project or engaging in contracts with new agencies, well, you need to understand their lingo. All right, so in order for us to understand trust in the state, we have to understand the defining words and what they mean. So we're going to go through a few of these so that as I'm going along and explaining and showing you different documents and how things are supposed to go, you will already know what I'm saying because we already defined the terms. All right, so certification in lieu of your trust document. A certification of trust. If you don't want to show your trust document, in most cases you can use a shorter version of it called a certification, certificate, abstract, or memorandum of trust, as I call it, and what's in the template is a certification of trust. Different states will use different names. This document gives institutions the information they need, but lets you keep some provisions private. Notably, you don't have to disclose the names of the beneficiaries to whom you are leaving the trust property. A certification is almost universally accepted in place of an entire trust document. All right? Many states have laws stating that if a certification of trust includes certain information, institutions must accept it in lieu of the entire trust document. California law, for example, states that someone who refuses to accept a valid certification and demands to see the whole trust document may be liable for any monetary loss suffered by the trust grantor. Declaration of trust. A declaration of trust is usually a document or oral statement indicating a property is being held for the benefit of another person or individuals. The trust grantor transfers the property as well as the designated assets such as cash and securities into a trust. An appointed trustee, such as an individual or financial institution, administers this trust in the best interest of the beneficiaries as explained in the Declaration of Trust. Breaking down Declaration of Trust. A Declaration of Trust outlines the trust is in benefit of, who can amend or revoke the trust, if it can be amended at all, who will serve as trustee, and what powers the trustee holds. The statement also includes information regarding what is to happen if a beneficiary wants to receive distributions. It can also highlight details about the types of assets within a trust. All right? Now, when you get into estate law, we will soon understand the true owner of any trust is the beneficiary. Okay, so the whole point of this webinar is to show you how to become the beneficiary. All right, because you want to own nothing but yet control everything, and the true owner of any trust is the beneficiary. Okay, now before I go into certain things, this guideline that I'm giving you this evening is universal. It doesn't matter if you're taking your steps of correcting your nationality, your status, or you're on secure party creditor. This is the foundation of everything that you are working on building, okay? So, let's carry on. Handwritten self-proving will. A stand-up written will describing the last wishes of the testate. Okay? What is the inter vivo trust? Inter vivo trust is a fiduciary relationship used in estate planning created during the lifetime of the trustor, also known as a living trust. This trust has a duration that is determined at the time of the trust creation and can entail the distribution of assets to the beneficiary or after the trustor's lifetime. The opposite of an inter vivo trust is a testamentary trust, which goes into effect upon the death of the trustor. Breaking down inter vivo trust. An inter vivo trust is important to establish because establishing a trust is to avoid probate, a process of distributing the deceased asset in court. This process can be lengthy, costly, and also expose a family's private financial matters by making them a matter of public record. A properly established trust helps ensure assets go to the intended recipients in a timely and private manner. How an inter vivo trust works. An inter vivo trust is an estate planning vehicle that can own the assets during the trustor's lifetime. The primary purpose of establishing a living trust is to make assets more clearly transferable to the trustor's beneficiaries without the encumbrance and expensive probate proceedings. In addition to eliminating the expense and delay of probate, a trust can always ensure the estate is spelled out without the publicity of probate. The ultimate benefit for the surviving family is the transfer of assets is conducted in a smooth and efficient manner to prevent any disruption in their use. While living in the trustor or trustors in the case of a married couple, can be the trustee managing the assets until they are no longer able, at which time a named backup trustee assumes the duties. A living trust is revocable, which means any of the provisions and designations can be changed while the trustor is alive. It becomes revocable after the death of the trustor. Action. With respect to an action of a trustee includes a failure to act. Now, I want to stop right here and pause before I go through the rest of these definitions, okay? Now, my definitions that I'm using is per my state, okay? Now, each one of us has a trust code, all right, for your state, where you are domiciling. You must go through and understand and overstand exactly your state's uniform trust code, okay? Now, this is why for this webinar, everything has to be general. It's a foundation. It's a fundamental foundation webinar because of the simple fact we cannot go into explicit detail on trust without having to go through each one of your domiciling state's trust code. And we would be on here for a year or two just doing that, okay? But in any event, if you go and you put in, let's say you're in Texas, or you're in Connecticut, or you're in Florida, Florida Uniform Trust Code, Florida State Trust Code, okay? Whatever derivative you want to use of that. Now, I'm reading out of my definitions and some definitions that I have also input into the document that we're reading off of, all right? But as you're going down your domiciling state trust code, what's most important is everyone will have the section called Methods of Creating a Trust, okay? So when you're starting out discerning your understanding of your state and how it operates, you first need to start with your state definitions, which they're going to be unanimous for the most part, and also through your state's methods of creating a trust, because that is where we get differences in opinions, okay? So let's make sure that we made a mental note of that and how things are different with regardless of what domicile we are in, okay? Ascertainable standard means a standard relating to an individual's health, education, support, or maintenance within the section of 240B1A or 2514C. Now, these are going to be my codes. And so, of the Internal Revenue Code of 1986. As in effect on January 1st, 2007, or as later amended. Beneficiary means a person that A, has a present or future beneficial interest in a trust, vested or contingent, or B, in a capacity other than that of trustee, holds a power of appointment over trust property. Charitable trust means a trust or a portion of a trust created for a charitable purpose described in Section 13-3B-405A. Now, when it goes into those, it's talking about my trust code. So when you go through your definitions, it's going to show you where it would be listed inside of your state trust code. Conservator means a person appointed by the court to administer the estate of a minor or adult individual. Environmental law means a federal, state, or local law, rule, regulation, or ordinance relating to protection of the environment. Guardian means a person who has qualified as a guardian of a minor or incapacitated person pursuant to parental or spousal nomination of court appointment, and includes a limited guardian as described in Section 26-2A-788E and Section 26-2A-105C, but excludes one who is merely a guardian ad litem. Interest of the beneficiaries means the beneficial interest provides in the terms of the trust. Now, if you're a part of Law Maxim and you're going through your nationality, there's a form called an Affidavit of Beneficial Interest, which is the affidavit of beneficial interest of the birth certificate, okay? So this is where that would come into play, but we can't go into that because this is the webinar that we are here for, all right? Jurisdiction. With respect to a geographical area, include a state or a country. This would also go into establishing your territory, establishing your boundaries. This is a tribal thing. If you're a part of the tribe, then you will understand how to use your coordinates. If you are not, then you are not ready for that class because that is a tribal trust charter course. but everyone needs to establish their jurisdiction. So when it is just you as an individual, your jurisdiction is kind of short, because your jurisdiction would basically be your abode, your domicile, all right? Okay. It'll be your abode, your domicile, all right? So, and that's why when you're coming with goods and home goods, like a conveyance, your conveyance would be an extension of your domicile, okay? So if you know a little bit about that, then that would make sense to you. Person means an individual, corporation, business trust, estate trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency, or instrumentality, public corporation, or any other legal or commercial entity. Power of withdrawal means a presently exercisable general power of appointment other than a power exercisable by a trustee, which is limited by an ascertainable standard, or which is exercisable by another person only upon consent of the trustee or a person holding an adverse interest, okay? Adverse interest, that is a particular trustee. There is a trustee called an adverse trustee. Now, when you are creating particular trust, which we will go through this, you should volunteer to want to be an adverse trustee. What is an adverse trustee? An adverse trustee is a trustee that is both a trustee and a beneficiary. So you're controlling one aspect of it. So let's just say you have a will, and the will was created by the estate. Well, the estate would be the grantor, right? And then you, as the trustee, well, the creditor, would then therefore want to be an adverse trustee, because you would want to be a trustee and a beneficiary to that trust, okay? Now, presumptive remainder beneficiary means a person who would be entitled to the principal of a trust if the income interest were immediately terminated, and if a trust contains a power of appointment, then the holder of such power of appointment shall be a presumptive remainder beneficiary. Property means anything that may be the subject of ownership, whether real or personal, legal or equitable, or any interest therein. Property includes choices in action, claims, and interests created by beneficiary designation under policies of insurance, financial instruments, and deferred compensation and other retirement arrangements, whether revocable or irrevocable. Qualified beneficiary means a living beneficiary who, on the date of the beneficiary's qualification, is determined. Are you seeing what is happening here? All right, we just went from beneficiary, which is a person, now we're getting down to living individuals, a living beneficiary, okay? A is a distributee or a permissible distributee of trust, income, or principal. B would be a distributee or a permissible distributee of trust, income, or principal if the interests of the distributees described in paragraph A terminated on that date, but the termination of those interests would not cause the trust to terminate. Or C would be a distributee or permissible distributee of trust, income, or principal if the trust terminated on that date. All right? Revocable, as applied to a trust, means revocable by the settlor without the consent of the trustee or a person holding an adverse interest. Remember, adverse trustee. Settlor means a person including a testor, all right, who creates or contributes property to. A trust is more than one person creates or contributes property to a trust. Then each person is a settlor of the portion of the trust property attributable to that person's contribution, except to the extent another person has the power to revoke or withdraw that portion. spendthrift provision means a term of trust which restrains both voluntary and involuntary transfer of a beneficiary's interest. State means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. The term includes an Indian tribe or band recognized by federal law or formally acknowledged by a state. Y'all did read that, right? But anyways, this form will be inside your folder. Terms of a trust means the manifestation of the settler's intent regarding a trust provision as expressed in the trust instrument, or as may be established by other evidence that would be admissible in the judicial proceeding. Trust instrument, I don't know why it's cut off, I think it's because I'm on read mode, means an instrument executed by the settler that contains terms of the trust, including any amendments thereto. Trustee includes an original, additional, and successor trustee, and a co-trustee. Intestate. If someone dies intestate, they have died without leaving instructions about who should receive their property. Many people die intestate because they thought they were too young to make a will. Testate. Definition of testate: having left a valid will, i.e., she died testate. Infant. An infant is the decedent of an estate or grantor, owner or trustor of a trust, guardianship, receivership, or custodian that has yet to receive a Social Security number. Okay? And then we'll go into grass whittle. But we're going to go a little bit further down. I'm going to get Taj to jump in here and read a little bit for me. Rose, I'm going to need you too, please, if you could. That'd be great.
Shalom, family. All right. We begin at birth. The Internal Revenue Manual, IRM, 21.7, 13.3, 22.2. An infant is the descendant of an estate or grantor, owner or trustor or of a trust, guardianship, receivership, or custodianship that has yet to receive a SSN, Social Security number. An infant is anyone under the age of 21. Your mother allegedly abandoned you at birth. Have you noticed the mother's address is already pre-typed in one of those boxes? Have you noticed there is no address for the father on the COLB? Have you noticed is the address of the mother's maiden, i.e. unmarried, name in that box? And have you noticed that they had the mother sign as the informant and not the father? You are considered an infant. Ward of the state. As your mother as the informant, a person who informs on another person to the authority. Signs your record of live birth, allegedly acting as the trustee of the executor's father's estate. If she declared she was married, then the father and mother are one in law, and thus the mother would have the same authority. As the father executor, however, as an unmarried woman, they assume she is acting as the co-executor of the estate, or in the capacity of a trustee, one with the authority to sign over property. However, she has none without her husband's approval. In a common law marriage, in a civil marriage, she has no authority. We must also note that the line of executor would fall on the nearest male relative. Not only is the mother without legal representation, no male is listed either. In fact, all male relationships are left off the documentation. There is absolutely no reason for the father not to be on the birth record, except for religion. Matthew 23:9, and call no man your father on the earth, for no one is your father, even he who is in heaven. The First Amendment clearly prevents the government from adding his name, i.e. prohibits the making of any law respecting an establishment of religion or impeding the free exercise of religion. Thus, the term father would impede the establishment of religion. Now, why would the Department of Health and Vital Statistics teach doctors, nurses, and hospitals administrators to coerce the mother into signing the certificate of live birth instead of the father, who is the executor of the estate? Because the executor is the highest office of the estate, and the state does not care to deal with him. They would rather go after the informant, trustee, instead. Attempting to administrate an estate without written authorized consent of the executor is very costly. People go to prison, but if they can coerce the mother, informant, trustee to sign over the property, then they appear to have a legal leg to stand on. However, it is all based in fraud. Keep as many people as you can ignorant. Then you can have the blind leading the blind, explaining the executor's office and the certificate of live birth. Note, an estate must come before a trust. The state issued the child a certificate of deceased. The grantor, via footprints, created the office for the new estate, the legal fiction corporate you, in which they were the witness of. The woman is her own estate in which she is the executrix. That's different from executor, guys, if she has reached legal age. If not, her father is the executor of her estate until that time. The man in his own estate in which he is the executor once he becomes of legal age or marries. Until then, his father is the executor of his estate. When they get married, her estate becomes one with his. If it is a civil marriage, they have both contracted with the state, not joined in a spiritual union with God, but two people cohabitating with the blessings of the state. The woman's estate now becomes property of the man in a common law marriage. In a civil union marriage license, the man controls the property. The two of them come together and have a child. The child is the property of the state due to the marriage license. However, the grantor created the office for the executor's use via footprints. Nonetheless, the executor's estate is abandoned until she reaches legal age, of course, unless the father or mother comprehends this stuff, as either the mother nor the father is ever made aware of this fact. The state coerces the mother into signing the record of live birth as the informant, presumably acting as the trustee. By doing this, acting as the trustee of the executor's estate, the father, and giving the child to the state, ultimately abandoning the child, you are the estate. How many people got locked up for child support or failure for non-child support? Just hold that for a minute.
Well, hold on, Taj. Hold on. Because child support is a trust. It's called a discretionary trust.
Mm-hmm.
So anytime that you get put on child support, the state creates a trust known as a discretionary trust, and then by that discretionary trust makes you a trustee and gives you powers and things that you're supposed to do for the benefit of the beneficiary, which is the child. And that's how you get child support orders.
I love it. Got it. Should I continue? Tiffany?
Yes.
You want me to continue?
Yes.
Okay. The state runs an ad in the local paper announcing the birth and the abandonment of the child. They leave out the abandonment wording. That was public notice and due process of the law. Fraud. Fraud is odious and not to be presumed. Thus, we must presume this is a valid contract unless you prove this point. When the contract is fraudulent, it is void. For fraud vitiates everything. As to cases when the condition consists of several parts and some are lawful and others are not. The whole thing is fraud unless there is a severability clause. Then only that part is to be singled out. The executor, father, never shows up to claim his abandoned property, so the state takes control. We must make note, I have never seen the record of live birth, only that of the certificate of live birth, and the COLB has the father's name on it, or someone presumed to be the father, or no one named as the father. Nonetheless, no one claims the abandoned property, i.e. executor or executrix, thus leaving the state or others to control the property. Now the infant becomes a ward of the state. The doctor sends the record of live birth to the state health department and vital statistics. The state sends the record of live birth to the registrar's office, where new estates will be recognized and now placed in probate. Note: will is desire, initiating action, having intentions to make things happen. The executor is to carry out the will of the grantor. The grantor being you, footprints. The estate being you, the office created by the grantor. You for the occupant. You to carry out the will of the testator. You for the one who is deceased. You. Number 12. They split the title and create what's known as a certificate of live birth and send that newly created office, the COLB, to the child in the mail. It's his or her new identity. And when the child reaches legal age, he can now become the occupant of the executor's office of that newly created estate, but is never made aware of this. Fraud, concealment of a material fact, induce another to act to his or her detriment. Note: the state cannot do business with or enter into contracts with a living, breathing human being. This is why they created the certificate of live birth, making you appear to be a fictitious entity. They had to turn you into a corporation so they could control you by way of contracts using trust, estate, and the probate law. Sestaque via Act of 1666 made us all dead at birth to protect our property. Thus, if you abandon the estate, cast beyond the sea, lost at sea, dead to the world. And if one day we were ever to return from sea and to announce that we were alive, we could take our lawful place as executors of our own estates. During this time, more ships... Oh, wait a minute.
Sorry.
More ships, more travel by sea, more people leaving the country for New World America, never to return. Definitions: revisioner, a person who possesses the revision to a property or privilege. Reversion, the right, ESP.
All right, now I want to go back up to the top to that definition, because now we need to get some clarity here. We have too many women creating bastard children, creating decedent estates, and our cultural difference. Now, every one of you that has been, put yourself on mute, please.
Yep.
Every one of you that have been on the trail of claiming your nationality, changing your status, doing your secure party creditor, you are null and void if you have not created a will or a trust. If you have not made yourself the executor of that estate, and by doing that, you can have a claim of life, and by doing that, you can be a general post. But if you have not took the steps of standing up as the executor of your estate, child, bye. You ain't nothing but a stateless citizen that belongs to a stateless nation of whatever quasi-judicial organization you are a party to. All right? Now I want to go back up because there were some definitions that I wanted to touch on. I think I strolled straight by it. Sorry, guys. Let me get there. All right. I want to go over to what a grass widow is. And I posted some of these on YouTube. I mean, not YouTube, but Facebook yesterday. I had some memes on there because this is clarity, okay? Grass widow and straw man, all right? And this is from a blog group, Oxford Etymologist, and it's a good read on explaining exactly what a straw widow is, because both of us on both sides of the fence need to understand. I woke up one day when I figured out trust in the state law, and I said, well, I thank the Most High that I was not born on a wedlock, and I thank the Most High that I know trust in the state law for the children that I created out of wedlock, so that I could go around and turn them back around and give them to the estate of my father, which I am now the executrix of. All right? So, straw is preceded by fresh green grass for this reason. I will begin with grass widows. Nowadays, a woman is called a grass widow whose husband had to leave home, for example, obligated to work far away from his family. Alternatively, she may be a divorced woman or a woman living apart from her husband, so in American English. In all those cases, she is not really a widow, but not quite a married woman either. Why grass? A definite answer does not exist, but a few things can be said with confidence. First of all, we have to get rid of folk etymology, according to which grass in this phrase goes back to French grace, with the whole alleged meaning courtesy widow. This etymology, one can find it in respectable old dictionaries and in letters to the editor. Should be ignored because exact equivalents of ing, grass widow, exist in German, Dutch, and Danish, whereas the French idiom is veuve de palais, I guess. I don't know French, y'all. That is straw widow. In English, the most recent sense, a woman living away from her husband, surfaced only in 1859 with a reference to India. Hence the often repeated conjecture that the first grass widows were the wives of servicemen. While the men sweated in the heat, the women waited for them on greener pastures. An older text, none of which, however, predates 1528. Grass widow has a much coarser meaning, namely, a woman who has lost her virginity before the wedding and a deserted mistress. Compare the definition from the 17th dictionary repeated in 1725. On that pretends to have been married, but never was, yet has children. In this context, many European languages use the word straw. So we have three riddles. Why straw? Why the substitution of grass for straw? In English, ing, straw widow, has never had any currency. And why the change from deserted mistress to wife, temporarily separated from her husband? As always, one finds some suggestions in notes and queries. That is what Thomas Ratcliffe Sick wrote in 1884. He said that if a man had to work for months on end at a long distance from home and his wife's conduct was not circumspect enough, she was said to be out at grass. And when her behavior was such that her next-door neighbors could not any longer bear it, a besom, mop, or broom was put outside the front door and reared against the house wall. The spelling has been Americanized. Nothing is more venomous than the wrath of the virtuous. We will restrain our indignation, but keep in mind the allusion to being out at grass or to be set aside. Our most solid evidence comes from Germany, where grass widow, competes with straw widow. Surfaced only in 1715 and has the meaning of in glass widow. As noted, the earliest English citation of grass widow has been traced to 1528. While in a German document addressed to pastors, straw brides, those who cohabitated with a man before the wedding, are first mentioned in 1399. Since the word for straw bride is used casually, we can assume that everybody understood it. Ignorance of the law is no excuse. In most probability, Germany is the country where phrases like straw widow and straw bride originated. Other languages must have borrowed it from German. The brides who came to the altar after losing their virginity, and this is the situation discussed in 1399 document, were made to wear a straw wreath. It's funny. If you look at depictions of Jesus, isn't he wearing a straw crown of thorns? Just saying. Maybe that's why he's a husband groom or a straw groom. But anyways, we ain't going to go there today. In some places, demeaning punishments were also extended to men. Straw bridegrooms who dishonored their brides. But straw wreaths are secondary. The idea of putting them on the head of a sinner came from the notion of the straw widow. Those who thought that straw or a bed of straw symbolizes extramarital sex, as opposed to the family bed, were probably right. A meeting between two lovers in a meadow out at grass, a secret tryst whose witnesses are the sun, flowers, and that little bird that knows how to keep secrets, is described in one of the most famous 13th century German lyrics. It contains a triumphant monologue by a love-swept maiden who are not told about the consequences of that rendezvous. A meadow is a place of pleasure. Reference to straw derives the situation of all its charm. The straw widow's path from the joy on the grass to intercourse on a bed of straw, humiliation of wearing a straw wreath, a relatively happy end. But more often to long life ostracism or exile, and occasionally death by a member of the woman's own family, a brother, for instance, as documents shown. The riddle of grass versus straw is insoluble, which reaching the history of the word strawberry. See it in the book World Origins. I discovered a little-known article that offers a plausible explanation of the puzzling name, a test only in English and locally in Swedish. In English dialect, straw was not too rare a synonym for grass, so that strawberry seems to have meant grass berry, berries growing in the grass. Regardless of whether this etymology is right, it provides a clue to the exchange between German and English, grass woman and straw woman. When English speakers took over the German word, apparently in the 16th century or some time earlier, they replaced straw with glass. There was no need to do so, for the noun straw would have been served the purpose equally well. Perhaps the borrowing occurred in an area in which straw grass occurred with some regularity. Such detail is beyond reconstruction. The rise of the word strawberry was also unnecessary. The most frequent name of this berry in Germanic language is like German elberry, earthberry, and its counterpart in Old English existed but yield to rare synonym that continues in the present. Okay. We should have a pretty good idea of what I'm saying when we're talking about a grass widow. So, what does this mean now? What does this mean for those of us that are grass widows, okay? Meaning that you are dead in the eyes of the law. Meaning, we are some little thoughts. We are nothing but thought forms that does not even create or manifest anything tangible in the earthly realm. You are a thought, and now you're an afterthought set aside in the valley of grass, waiting, and you're a widow. You are dead in the eyes of the law. And that's just what the trust and the state law tells you. But now that you don't figure that out, put your boots back on and let's go. Because now we need to know, what about these illegitimate children that we have produced in the making of these rendezvous? All right? What does this mean for them? What is it that we've done here? All right? So this goes for men and this goes for women, in regards to these things. So these bastard illegitimate children born in a relationship between two persons that are not married, not in wedlock, or who are not married at the same time of the child's birth. What does this mean for them? What does this mean for them? Okay? I'll tell you what it means. If you have a child, and then we'll go through some of this too, being born out of wedlock was significant as it deprives a person his otherwise inheritance, which was usually the only way to acquire real property. The church recognized bastards if the natural parents subsequently married. When England was just sorting out the new beast called a parliament, the very first set of statutes, all right? Now this goes in to talk a little bit. The link's going to be in the paper, all right? So the advantage sometimes to being a bastard, except for genealogists, was that the bastard did not take his father's surname. They were considered born without any surname and could choose anyone they liked. Bastards were of a such lower caste in medieval England. The Latin expression for developed just for them, labeling them son of nobody, son of the people. All right? Blackstone and his contemporaries of the law of England, 1765, said that a bastard could not be a heir to anyone. Neither can he have heirs, and could be legitimized only by the act of Parliament. Now, this still stands in a state law in America today. If you are a bastard that was born out of wedlock, and this could be you. We could be talking about you right now. All right? We could be talking about you. We could talk about me. However, if your parents were not in wedlock, whether it be common or it be statutory marriage, you are a bastard. Period, point blank. And that means that you have no claim to any inheritance because you are a dependent of the state. And so this right here will make you want to think about becoming the executor or the executrix of that estate. And this is why when we're going through the process of doing the name change in the nationality, you do not change that last name, because that last name is the estate. You only annex into it or you come in syntax. Because if you change that last name, you've abandoned the estate completely, and the whole new certificate starts over, and you have a whole nother 18 years to reach consent to even make it even monetary of value. So let's make sure that we understand that. Do not abandon your estate by changing your name. Who is that? Do not do it. I'm telling you, do not do it, because you just created another security. You killed that security when all you had to do was create your handwritten, self-proving will and your inter vivos trust. So keep in mind, do not do that. All right? Taj or Rose, whichever one, I'm going to go back over here so we can finish picking this up where we were just at.
Where are we at?
We are on the notes Sesquive or Sesquive Act of 1666. Also check out the Sesquive. I don't care how y'all pronounce it. This is how I talk. All right. So anywho, 1666 or 1707 is the new one. All right. But I have all those documents in the drive when you get there. All right. Okay. Go ahead, Taj.
I know where I was. Hold on. Of the original owner of the heirs to possess or succeed to the property on the death of the present possessor or at the end of a lease. A property to which someone has such a right. The right of succession to an office or post after the death or retirement of the holder. Sesquive. The person for those who use their fiefment was made. Fiefment or infiniment, I think that's it. Rose got to help me out. In English law was a transfer of land or property that gave the new holder the right to sell it, as well as a right to pass it on to their heirs, or as an inheritance. It was total relinquishment and transfer of all rights of ownership of an estate in land. From one individual to another. Recitals the part of his legal document that explains the purpose of the deed and gives factual information. Revert of property, return or pass to the original owner by reversion. Tenement, a piece of land held by an owner. Law, any kind of permanent property, e.g. lands or rents, held from a superior warrant. A document issued by a legal or government official authorizing to carry out some action relating to the administration of justice. To justify, vindicate, call for, sanction, validate, permit, authorize, deserve, excuse, account for, legitimize, support, license, approve of, merit, quality, for, rate, be worthy of, be deserving of. To guarantee, affirm, swear, promise, vow, pledge, undertake, state, assert, declare, profess, attest, vouch, testify, bear witness, formal, aver. Here it is on the UK's government website with complete instructions on how to announce you are now alive. Occupy the executive's office. Sesquive Act 1666, an act for redress of inconveniences. Yes? Did you say something, Tiffany?
Yes. You want to be the CEO of your own corporation is the point. You would not be so concerned about other jurisdictions and their corporations if you were minding your business. You would not be concerned what Trump is doing as the chief executive officer of the corporation of the United States of America if you were over here being the executor and the executrix of your own estate, which is the United States of America. Thank you.
So you mean if I become the CEO of my stuff, I ain't got to worry about black sweaters and white sneakers?
Right. The whole point is this. If you are concerned about what others are doing and what others are thinking and what others feel, then you're selfish. And what I mean selfish is that you are ish. You are something like yourself. You need to be self-centered, because if you are self-centered, all of that doesn't apply to you.
Oh, wow. I'm Rick James. All right, moving on. All right, Convey Act 1666, an act for redress of inconveniences by want of proof of the deceases of persons beyond the seas or absenting themselves, upon whose lives estate does depend. Recital that Convey has gone beyond the sea, and that revisioners cannot find out whether they are alive or dead. Whereas diverse lords of the manors and others have granted estates by lease for one or more life or lives, or else for years of determinable upon one or more life or lives, and it hath often happened that such person or persons for whose life or lives such estates have been granted have gone beyond the seas, or so absented themselves for many years that the lessors and revisioners cannot find out whether such person or persons be alive or dead, by reason whereof such lessors and revisioners have been held out of possession of their tenements for many years after all the lives upon which such estates depend are dead, in regard that all the lessors and revisioners, when they have brought actions for the recovery of their tenements, have been put upon it to prove the death of their tenants, when it is almost impossible for them to recover the same. For remedy of which mischief so frequently happening to such lessors or revisioners, Convey remaining beyond sea for 7 years together, and no proof of their lives, the judge in the action to direct their verdict as though Convey were dead. So after 7 years, that baby is dead. If such person or persons for those life or lives such an estate have been or shall be granted as foresaid shall remain beyond the seas or elsewhere absent themselves in this realm by the space or 7 years together, and no sufficient and evident proof be made of the lives of such person or persons, respectively, in any action commenced for recovery of such tenements by the lessors or revisioners, in every such case, the person or persons upon whose life or lives such estate depends on shall be counted as naturally dead. And in every action brought for the recovery of the said tenements by the lessors or the revisioners, their heirs or assignees, the judge before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the sea or otherwise absenting himself were dead. Go to court and say you black, and you're a black person. If the supposed dead man proved to be alive, then the title is reverted. Action for mean profits with interest, provided always that if any person or persons shall be evicted out of any lands or tenements by virtue of this act, and afterwards, if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, shall on proof of any action to be brought for recovery of the same to be made appear to be living or to have the same, living or have been living at the same time of the eviction. That then and from thenceforth the tenant or lessee who was ousted of the same, his or their executors, administrators, or assignees shall or may reenter repossess, have hold, and enjoy the said lands or tenements in his or her or their former estate for and during the life or lives or so long term as the said person or persons upon whose life or lives the said estate or estates depend shall be living, and also shall upon action or actions to be brought by him or them against the lessors, revisioners, or tenants in the possession or any persons respectively which since the time of the said eviction receive the profits of the said lands of tenements, recover for damages the full profits of the said lands or tenements, respectively, with the lawful interest for and from the time that he or they were ousted of the said lands or tenements and kept or held out of the same by the said lessors, revisioners, tenants, or other persons who after the said eviction receive the profits of the said lands or tenements or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estates or estates did depend or are or shall be dead at the time of the bringing of the said action or actions as if the said person or persons where they then living. If you want your 40 acres and a mule, this is how you get it. Not protesting. Scroll, please. Scroll.
Hold on a second.
I'm impatient.
You'll be all right. All right. So there's a few things I want to touch on right here. All right. How were you claimed as a decedent estate? You were adopted by the Crown and baptized in the Catholic Church, and then you became a dependent and was created an estate off your certificate of birth. Okay? Now, this is the C son for all debts to be repaid and for reclamation of estates. All right? This is when all debts are due. Isn't it tax season on their fiscal year? So all of our C sons and C daughters need to return from the sea to their land on shore. So you need to come ashore. Out there drowning in debt in the high seas of commerce, you need to go ahead and get forgiveness to come with your hands clean and come the executor of that estate. All right. So, I'll pick up here, Taj. Thank you. Now, the child grows up and remains an incompetent ward of the state because she never steps up and assumes their proper roles as the executor, executrix of their own estate once they reach legal age. The now adult uses the COLB as their sole source of identity, even though the state advised not to use it as identity. Can you say incompetent? Just as they say not to use a Social Security card as identity. Oddly enough, the same government that says not to use a COLB demands that we do use a COLB in order to get permission to do things or privileges like driver's license, work, get a Social Security card, checking account, etc. These are privileges that we are accepting. All right? Now, even if you go through the Social Security Administration Act, per the commissioner of the Social Security Administration, which is the person that creates and issues the Social Security account numbers. If you are a dependent, if you are accepting privileges from a state, that means that that state claims you as a dependent and they are liquidating your Social Security account. It says it all in the Social Security Administration Act. You might need to go read that. It says the purposes of birth certificates. It says the purposes of death certificates. All right? So y'all want to check into that. Now that adult competent is masquerading around town using the certificate of live birth as identity, get into all other adhesion contracts and basically acting as the agent of the foreign corporation known as the United States. Presumed to be a U.S. citizen is not obligated to pay an income tax, an excise tax, a property tax, and ultimately to be subject to the state. Now you are obligated to abide by their statutes, rules, and regulations. So hold on. Don't go out there and get belligerent now. Note, there is a catch to this. They are presuming you are an employee of their corporation. But if you are not receiving a paycheck and there was no employment contract and they cannot prove proof of pay, then what do they have? Do you work for free? Because volunteer, it does not aid. Well, equity does not aid a volunteer, beloved. Equity does not aid a volunteer. Can you compel your work for free? That COLB is an office. You are the occupant of that office. And as the occupant of that office, should you be paid for your services? Is no workman worth his hire? Without taking a hold of the office as an occupant, you have lost your inherent rights and have been granted rights and privileges instead. You are a tenement of your own estate. Like being a renter to your own home and have to pay someone else for the privilege to live on your own land. You better get you some of that sovereign soil tax. Daddy never showed up to claim his property, and the state took it upon them to presume the child is theirs to control. Another maxim of equity. A trust will not fail for the lack of a trustee. Take it in as their own. The child is now considered a ward of the state, an incompetent bastard child with no father, and the mother abandoned him. Damn. The certificate of live birth has a state seal and registrar's signature, which is certifiable proof the estate is in or has been in probate. The registrar is the court of probate, and probate deals with the state of the deceased, one who is in an act of dying. The courts where we are all dead, missing in action, legal fiction entities, wards of the states, bastard children, orphans, essentially infant, which means unable to speak. They do not wish to deal with us directly. This is why they want an attorney to speak to them. The bar attorney has a superseding oath to the bar, aka the British Accreditation Registry. Their first loyalty is to the court. They are there to lead the sheep to their slaughter. The undertaker in the black robe. The judge is administrating the estate of the incompetent, and his main objective is to make revenue for the state, which is acting as a beneficiary of the estate. And you and I are being put into the trustee position of our own estates. Now you understand why the Lord said, "Woe unto ye lawyers." Bar attorneys' first allegiance is to the crown, not you. They are all there to make you believe something is fighting for you. But the truth of the matter is they are all there to help the presumed administrator of your estate, the bar attorney wearing the black robe undertaker. Make as much money as possible for the court, him, herself, and the state. Read it again at the top of this post, right out of the Corpus Juris Secundum. All right. You are a ward of the state, an imbecile, a menace to society, an incompetent, essentially unable to speak intelligently, an infant that is the truth. Take it as you will. Note, I'm not saying all attorneys are scumbags that are intentionally trying to harm you. Some of them know what you are doing, and some of them probably truly believe that they are doing the best they can to help their clients. Pity the fool. But if it is all about the state, it is all about the money, and it is all about your slavery and unjustly enriching the state in the end. The house always wins, doesn't it? It is a constructive fraud upon your birth, and that is my heartfelt opinion. Take it as you will. We all have free will, don't we? That means a lot right now, having free will. Therefore, claim your rightful inheritance. Claim to be living, or better yet, the executor of the estate. You can come to clean up the mess of the trustees and those who are acting without you giving them authority, i.e. warrant. All right? We're going to stop there for right there, okay? But that should have gave a lot of us clarity to exactly what is going on. A lot of us forget when we're going down this journey that it all started with that certificate of birth. Did it not? But some of us done got distracted. You done got tracted into disease, which is disease. And now a lot of people are out here knowing that they're under occupation, being belligerent. No, you have to come back on land and claim your estate. Okay? It's that simple. This is where it starts. period, point blank. So now we're going to go over into some of these documents on how this actually breaks down. Now, everybody that's in this webinar will get a link with these documents in there when we close out. This is the page right here that we're reading from. All right. So let's get into the templates so I can show you guys how this is supposed to go. I would advise if you come to a webinar that you should be keeping notes, but the recording will be available as soon as I upload it onto here, okay? Now, the first thing that we were talking about would be the certification of trust, all right? The certification of trust is an abstract of your actual trust, okay? Now, this is what you would file in your probate division. I do not file my declaration or my deed of trust nowhere. That is private, all right? So as we're going through some of these documents, if it says private, that means it is private. And we need to know not to commingle private and public, okay? It has nothing to do with a lot of things that people get it confused to be. There are things for, this is for the masses and this is for the few. All right? So come on and let's get this together. Now, the certification of trust, like I was saying, is an abstract of the complete declaration deed of trust, okay? So it goes through, and these are fillable templates. So when you get them, you'll be able to go through it as you wish, okay? So it's pretty much just a standard overview of exactly general provisions, the trustee's power, specific powers of the trustee, retain trust estate, all right? Hold investment cash in underproductive property, invest and acquire, options, warrants, puts, calls, commodity and margin accounts, exercise options and conversion privileges, receive additional property, sell and lease, insurance, lead, borrow, term or duration of obligation, compromise or abandonment of claims, distribution in cash or in property, use of the nominee, bid on or take over without foreclosure, pay off encumbrance, vote stock, participant in reorganization, purchase property from a state or trust, employment and assistance and agents, establishment and maintenance of reserves, manage realty, carry on business. When it's inside the drive, it's going to populate like this because it's showing us how it would look in Google Docs. Now, when you go into this drive, let me make this understood right now. When you go into the Google Drive, guys, download the documents. Because if you open these documents in my drive, then you're going to make a copy of all your information and put it back into my drive. And I don't want it. I don't want to be in receivership of that. Okay? Carry on business with respect to any business that may or... okay, let's keep going. And then it goes on to a lot of things dealing with the trustee, compensation of the trustee, bond and qualifications, successor trustees, removal of successor trustees, delegations, limited power to amend, carrying several trusts as one estate, allocation to principal and income, prohibition of alienation, disclaimer, elections, certain distributions, use of residence, okay? And then it goes on. Now, mind you, this is just a certification of trust, okay? Now, 3 things that need to be in your certification of trust, all right? 3 things need to be the name of the trust. So, if your name is Tiffany Gabrielle Israel Living Trust, that's the name of your trust. Okay? And then that would be abbreviated because you can abbreviate these. Trust is abbreviated TR. Trustee is abbreviated TTEE. Now, there's a couple of other things that I want to get into when we're talking about trust. All right? Because now we're going to get into talking about stand up. stand-up holographic wills. Okay? Now, when you are doing a holographic stand-up will, stand-up means that you have made witnesses, which makes it a formal will. Okay? Meaning when you write, okay, a heliographic will is handwritten. All right? So, you can write out the name of this is my last will, this is my last will, okay? Which now we're going to change that heliographic will that is handwritten into a self-proving will that can stand up in court, okay? This is very important when you're doing this, okay? Now, a self-proving will is a will that describes your last wishes. You are a testor. You die with a will. You want your will to stand up in court. Stand up means you have witnesses that make it formal, signatures that are notarized. Then it is a self-proving will. The notary is proof of valid and legal witnesses, okay? I would hate for you guys, because a lot of states do not have civil notaries. There are only 2 states. I reside in one of them. And if you ain't in one of these 2 states, then sorry for you. You cannot self-declare, certify, or none of that, especially if you ain't got no great seal to even apostle or authenticate nothing. All right? Now, the reason why you want to do a notary on your handwritten will, okay? Now, your handwritten will can be very simple, okay? Your handwritten will can say, I, Tiffany-Gabrielle, Israel, leaves everything that is an attachment. What do I mean by attachment? Let's go over there. Let's look at this. What is an attachment? Because this is very important because it goes with your will. When you write your will, any and all and future things with this attachment is going to list all of your property. It's a property list. And this property list is still an abstract of a private security agreement, and that's private, and then you have a commercial security agreement, okay? So you can do it one or 2 ways. You can attach the property list like you would with a UCC, or you can attach a commercial security agreement. Mind you, the declaration of trust and the private security agreement, they do not mingle with the public. Anything that says private does not mingle with the public. So when you are mingling in the public with your trust, you should be carrying your certification of trust, which is the only trust that you're filing except for that handwritten will in probate, and it would be that commercial security agreement. Okay? Now, when you do your handwritten will, you sign out. You can put it however you want. It can be just as simple as you want or just as simple as not. I have to give everything and all to the Tiffany-Gabrielle, Israel Living Trust, executed today. Okay? Now, this is what is going on. We just read that you already are deceiving the state, so you're already in probate, beloved. I hate to break your heart like that, but you're a zombie. But you're going to be all right. We're going to have redemption hour. All right? So, you need to get that property out of probate. How do you do that? How do you convey an estate out of probate? How do you do that? By changing the name of it. Because when you do a name change and it is granted, the word granted means to convey or bestow. So when you go and do your court order name change, that means that that probate judge has relinquished that estate unto you, and now it has been conveyed into your care, in which you wrote a will with proper instructions that all of the property of the estate is to be conveyed into the living trust of who? You. All right? See how simple that was? Now, all right. Some of y'all, I think I just caught the Holy Ghost. But that's exactly what you want to do. You want to convey that estate into that inter vivos trust. All right? Now, another reason why you want to get that handwritten will notarized is, let's just say this. You made your grandmother was a witness and you did notarize it. Now you done passed away in life, like you really fleshly passed away, right? Well, grandma done been dead. So how are we going to, the validity of the contract is null and void, because now we're in court and they're like, well, we can't execute this will because we have no public official of the court that had notarized and said that they were even in sound, competent mind when this was created in the private. So forget all that. We're just going to probate the estate. You know, that's exactly what we're going to do. Okay? So let's be very particularly clear on when we're doing things and how to do them. Okay? You cannot operate in a civil common law matter if you are still lost at sea, you don't know how to contract, and you're a debtor. That don't mix. That don't go together at all. It doesn't even go nowhere. All right? Now, with that handwritten self-proving will that has stand in law needs to accompany a power of attorney. The power of attorney is the decedent estate giving the creditor power of attorney. Okay? So this is giving the straw man, the illegist, is giving the name change creditor power of attorney. Has to go with that handwritten will. All right? Needs to be notarized. All right? This also needs to be printed on 32-pound, 100% cotton paper as well. All right? Now, along with that, you have the private security agreement. Now, this private security agreement is 14 pages, okay? But the commercial security agreement, which is the abstract of this, you guys need to take your time, go through these documents, all right? I'm not going to sit here and read this whole document because you need to have understanding on exactly what this document says and how it does for you. This is claiming all of your intellectual, biological essence. This is claiming the essence of you, mind, body, spirit, and soul. Okay? So this is something that you need to go through and read through. Okay? And make sure that you're putting the things that are conducive to your lifestyle. Okay? This private security agreement goes with your children, their securities, any other deceased relatives that you have need to go in here. It goes very in detail on all of the property that is considered in here. All right? It starts at paragraph B, which is exactly the attachment form that we were just reading, okay? So it goes through a lot of information, as you can see. All right? So you will see this throughout the document, where you put in your children, where you're putting death certificates, birth certificates, Social Security accounts, EIN numbers, and things of that essence. All right? And then the commercial security agreement, which is over here, is the abstract of that. Okay? Now, hold harmless indemnity. You need this to go along with it. Why? Because you want to be indemnified from anything that has happened from the estate, meaning you don't want to inherit on your full faith and your full credit the debt of the decedent. So you need to have a hold harmless and indemnity agreement that goes with that, because you are the authorized representative. You are the one that has received the debt, and you are discharging the debt. Okay? So you don't want any of these debt collectors to come after any assets that you have inside of that living trust, because you are indemnified against that. All right? So you guys read through this one and go into it. And it will list everything that you need to do, okay? Now, when labeling your documents, some of you should be astute with labeling, but if you are not, all right? And then we're going to get into why this registered mail number is on the top. But before we go there, HHIA, hold harmless and indemnity agreement. The exact way that it is titled, hold harmless and indemnity agreement. Then however you want to categorize your document. You can do your birthday hyphen with your initials if you want to. Okay? Same thing goes for the private security agreement and commercial security agreement. They need to be labeled the same, which you will see that they are when you open them up on the bottom of the footer. Okay? They all need to be labeled exactly like that, whether it be page for page or whether it be in the beginning, however, because that is what you would put on those UCCs. Today is not a UCC class because that's a whole nother, we'd be over in Lex Mercatoria and all sorts of things, okay? Because you don't operate in commerce. You're not commercial. You're a merchant. You're a merchant. You're merchant. Mooring, mermaid, and merman, and mooring on the navigations of water because you know how to operate in commerce on the high seas. Check yourselves out on your definitions and the way that you classify yourselves. All right? Another thing is this. Let me get back over there. If I can get back over there. Whoops. Now, so on a recap, for your handwritten, self-proving, legal standing will, the attachments that go with it when you file it will be a commercial security agreement, a power of attorney, a hold harmless indemnity agreement. Okay? Now, your private security agreement is separate. Okay? Now, another thing is this. Now we're moving over into the inter vivos trust. All right? Now, the same attachments go for every entity that you are creating. All right? Now, we have the certification. This is when the certification of trust comes into play in the inter vivos, because we just went over that the handwritten, self-proving, legal standing will was handwritten, and it was simple, and it was to acknowledge that all property, goods, and everything reflected in the agreements that were in the attachments is to be conveyed into this inter vivos trust. Okay? Now, the reason for the inter vivos trust is because it's a pass-over trust, it's a pour-over trust, meaning it is the remainder man vehicle. After you successfully expatriate and you have killed your straw man in all entirety, all of the assets of that is to be conveyed into this inter vivos trust. Now, side notes on a couple of these things. If you have property that is still in that decedent, it needs to be transferred into the inter vivos trust. And that is how you fund your trust. Okay? Don't go on no mystical carpet ride on funding a trust and go to fucking federal prison. Okay? Because you ain't in my tribe. I'm not coming for you. All right? So, funding your trust is very simple. A trust is not valid until the trust is funded. And you can easily, it's very simple to fund the trust. Very simple. I'm going to show you how simple it is to fund a trust. Most of you already have bank accounts. All right? This is a very simple way of funding your trust. Go to your bank and redo your signature card, making the inter vivos trust the owner of the bank account. It does not have to change the name. It does not have to change the checks. It does not have to change the debit cards. They all can be the same. Nobody has to know that a trust owns that bank account except for you and the bank. Now, when you go to the bank with your certification of trust, right, and your commercial security agreement, that's what you give them. All right? And then they'll say to you, well, what is the EIN of this? Now, depending on how you're doing this, an EIN of a trust by law is a Social Security number. But wait a minute, you're an infant, and by the eyes of the IRC, you have never been issued a Social Security number because you're an infant decedent. So that would be a negative, right? And now we're talking about jurisdictional approaches, which is where we get into foreign EIN numbers. Now, I would advise all of you to get these foreign EIN numbers if you have not already, because you never know what tomorrow brings. All right? Now, with the foreign EIN numbers, I have two examples here. Okay? Now, this is exactly how your SS4 should read. All right? Now, the name change living trust. So, if you are annexing into a noble title, then it would be your birth name, hyphen, El Debe Ali. However, if you're not with none of that nobility, then you need to put your name and change it to proper syntax, which would be first name, hyphen, middle name, semicolon, last name, upper lowercase. All right? And that would be the name of your living trust. Okay? Now, the mailing address 4A and 4B will be your domestic address that is not associated with that estate. It would be really interesting for you to call the IRS and let them say you ain't got no social, but give them your mama's address that you used to file your taxes last year, so they can laugh at you, hang up in your face, and yeah. That just doesn't make any sense, because now we need to step outside of the corporation, which is the state. This is very important, and this is the whole reason of getting 9-8 numbers, is so that you step out of the jurisdiction of being the state, because the state has already claimed that Social Security number as a dependent because it's received privileges and benefits and rights instead of liberties. Okay? So we need to step outside of that. And by creating this 4 and 9-8 inter vivos trust that we've conveyed the estate, what does that mean? We have took a domestic estate and pulled it into a foreign jurisdiction, thus making you foreign executor of a foreign post. That's simple. That's simple. And we didn't have to go nowhere but call the number. Now, the number that you need to call to get these numbers would be, I'll give it to you here. Let me pull it up. All right. Foreign EIN number 267-941-1099. That's interesting, isn't it? Numbers don't lie. You know, just learn how to follow the guides. You want to do 1099 OIDs? Well, I guess you need to have a foreign 9-8 number from 267 941-1099. That's the number. Okay? So you call that number. Now, another thing is, when you're doing your foreign address, okay, because this is what makes the difference between domestic and foreign. All right? So when you're doing your foreign address, my advice to you would be to get a foreign address that is not in the Hague Convention territory. So if you have an authenticated birth certificate, use an address from that same country. Because if you got an apostille, if you have an apostille, then you need to go rip that off and try it again and get it authenticated. And the difference between apostille and authentication is an apostille is domestic. It's inside of the Hague Convention. Authentication is outside of the Hague Convention. All right? And then you can go into getting further information on that, but through the Hague Convention Territory Act, also through the custodian alien property, and then it keeps going all the way to trading with the enemy. You want to be set aside from all of that, okay? So this document, if you fill yours out exactly how I filled mine out here, you will not have a problem. You can actually, what is that? I think it's 10:30 y'all time because they close later. Well, it's Sunday anyways. Tomorrow morning, make sure you call the IRS and get your 9-8 numbers. You don't know what could be going on the 14th, all right? So, excuse me, guys. Got tongue-tied. Along with these EINs, this is paramount, okay? This is paramount. Now, the same thing goes for your registered holding trust, All right? Now, the only difference between your registered holding trust is where you have, when you go after you get the 98 number for your inter vivos trust, you need to open a registered mail holding trust. Okay? Now, the only difference between the last SS4 we were looking at and this SS4 is on 7A, we now have an EIN number. So on 7A would be the name of the creditor. It would be the name, change you, right, living trust, and the EIN number that you just got. And that's where you would put that. It's exactly the same in format and everything as it is, okay? So, and then you would title it however, just the same way you would do it, just as this. Now, there are other tax documents if you're going through your status correction that you really need to get together. Your 8832s, your 8822Bs, your 1040Bs, your Form 56s, your appointment of fiduciary, your W-8 Ben. That is part of your IRS status correction. So if you have not yet to get those documents together, you should be doing that this week and getting them sent off, okay? So that there is no problem with if they are in receivership of it not. Rather, this corporation that you are subjugated to is closing down, but you might want to get on that, okay? So, and that's how you do that. Now, when it comes to the registered mail holding trust, okay, let me give you a breakdown on how this goes. And I'm going to use a family in example. We're working on family dynamics, all right? Now, let's say his intro vivos trust and she has an intro vivos trust, all right? They decide to be in matrimony. So they come on over to Minister Tiffany Gabrielle Israel and they say, hey, Tiff, yeah, I don't want to be a statutory no more. I need to be in holy matrimony. Cool, check it. Do you wed the in? Here's your certificate of matrimony in which you would file at the probate, giving them acknowledgement. And now both of you create a joint trust. All right? Inside of that joint trust, which would be a holding trust, it is what is holding all of your assets in the mix of you commingling with each other. You are in matrimony, okay? So the both of you, your inter vivos trust and her inter vivos trust, create a subsidiary joint trust, which is the registered mail trust. Now, why is it called registered mail trust? Because in the event somebody sues you, they're going to get stuff out of that trust. In the event somebody sues her, they're going to get something out of that trust. But whatever you put in the name of a registered mail trust or any other trust, it can be a family trust if you want, but I wouldn't do that because if you make it a family trust, it's still got your name on it publicly, okay? So if you do it that way, people can still find a way of getting beneficial interest into that, okay? They can lien a trust. A trust is an entity at the same time. Just having a trust does not completely secure you, especially if you don't know how to contract. Let's make that clear. Another thing is, an inter vivos trust is community property in marriage, so it is counted as a marital property. So the idea is for you to take your handwritten, self-proving, legal standing will to create your inter vivos trust. She should do the same, and then out of that creates the holding trust, where you would hold all of your property. So in the event something happens to you or something happens to your wife, your living trust and her living trust will be absorbed into that registered mail trust so that it is a bypass trust. It will pour over, all right? And that's where you would hold all of your community assets. It is also the trust that you would create business trusts out of, nonprofits out of, LLCs out of. All right? It would come out of that registered mail trust because you own nothing, control it all. Okay? So if your registered mail trust creates a LLC, how are you liable? So that completely, the LLC doesn't even matter no more because you're still not liable because the trust created the corporation, not you. Or if you want to create other business trusts, that is where you would put it, in that holding trust, okay? How do you do this holding trust? Well, you need to go get you some registered mail labels, not the one that says registered mail, you need the ones with the numbers, all right? Let's go over here and look at that. I'll drop that in there for you guys. Yeah, I'll drop it in there. I'll give it to you. Just the gift that keeps on giving. Let me pull it up, and I'll give it to you because y'all need to get this done. All right. With the registered holding, registered mail, these are the instructions. Your estate can mail your creditor a registered mail label. You want to pay for the insurance. All right? You pay for the insurance because now you've created a registered bond. The post office is a bank. It accepts deposits. It hands out lawful money, known as money orders that are embedded with lawful silver. Okay? So you want to mail this to yourself, just like this, in this form. Okay? Now, once it has circulated, you're going to do your UCCs. We're not going into UCCs. We can do another webinar if y'all request. Doesn't matter. If you're already in here, you'll get it anyways. But you're going to do your notice of claim and your notice of transfer. All right, which you would file miscellaneous. Now that you have noticed and claimed, you have claimed and transferred this registered mail number, this number goes on all of your documents. Okay? So, just as we were looking earlier, just as we were looking earlier at the documents, and I was like, I'll show you what the registered mail means. This is your registered identification number, okay? So when you're going into being a creditor, this registered mail number is the number that you're putting on that registered bond. That's why having insurance. Insurance is nothing but a bond, and you want to be registered, all right? So as you can see, let's open one of these. How it's up here at the top. That is your unique identifying number. All right? If you want to go further in your studies to being a postmaster and things of that essence, you still have to have a registered number. Okay? So that's where that would go on all of your documents. And that is your document identifying number. Okay? I'll post that in there. Another thing that your guy is going to need with that, which I'll post in there too, would be the notice of claim, notice of transfer. All right, it's very self-explanatory. It's just like this. So you put your name, where you're recording it at, the registered mail number, notice of claim. And then the notice of transfer is exactly the same. File it miscellaneous in your county court. Okay? And that's how you would do that. Now, let's finish this up. I want this recording to download and everything before the night's over. So we're going to finish carrying this out, and then I'll close out and answer any questions that you guys have. I see some things going on in the chat. I can't read the chat and the document at the same time. So once we finish this document, we will come back so that you can read. Is Rose, or can you start reading, or Taj, do you want to pick back up?
Hope volunteered, just to let you know.
Well, shalom, beloved. All right, Hope, when you're ready.
Hope.
Let me see, she might be on mute. I think this is her right here.
7.
I got you.
Yep, that's
You're
me.
on mute. All right.
So it's Affidavit of Marriage?
Yes, ma'am.
Okay. Shalom, everyone. An affidavit of marriage is a document submitted to a court, university, or other institution in order to verify that a person is married. A person might need to verify their marital information to get health insurance or to get a passport, visa, or other government documents. Common situations where an individual might use an affidavit of marriage include a marriage record that has been misplaced or destroyed, an incorrect or incomplete marriage record, supplementary proof of marriage information submitted along with a marriage certificate. Once an affidavit has been completed, it can be used as a convenient alternative to an official marriage certificate. How to use this document. This document should be completed by a person known as the affiant who can attest under oath to their personal knowledge of the circumstances surrounding the marriage. This person could be the other spouse in the marriage or someone who was present at the wedding, like an officiant or close family friend. The document includes information identifying the affiant, including their name, address, and birth date. The document then goes on to list information describing the wedding, such as the date and location. Finally, the document explains how the affiant and the subject know each other and the source of knowledge about the circumstances surrounding the subject's marriage. Once the affiant completes the affidavit, they should sign it and have it notarized. The subject of the affidavit should keep the notarized affidavit in a safe place, such as a safety deposit box, so that it will always be available to use when they need proof of the marriage. Applicable law. There are no laws outlining exactly what must be put into an affidavit of marriage. There are, however, some generally accepted practices for creating such documents, including making sure the information is robust enough to be persuasive to an authority, that the affiant is qualified to attest to the circumstances surrounding subject's marriage.
All right, guys. Thank you, Sister Hope. Now, I'm going to open this up for some questions here. I see a lot of people go gadget in the chat room. Now, this is valuable information that I'm about to tell you guys, okay? On anything dealing with trust, there are 3 things that you need to have. You need to have the name of the trust and how you would write this. You need the name of the trust, the date the trust was created, and the name of the trustee. Because of the simple fact of this, you can go and create another trust named the same thing, but it has different assets and different property. So how are we going to distinguish between the 2 entities? This is very important. When you are conveying property, if you want to fund your trust with a car, now, if you want to fund, let's say you own a car right now. You need to put it in your trust, all right? How you would do that is you go on down there and you need to review your title. And how you would do it is you would put exactly like this. Tiffany - Gabrielle / Israel Living Trust UA under agreement. And then you put the date you created the trust. So if you created your trust today, it would be Tiffany - Gabrielle / Israel Living Trust, and then you would put TR for abbreviated because you only got a small little bit of room. And then under agreement, which is the trust agreement, the date would be 2/10/2019, and then the name of the trustee. Okay? That's how you would do that. All right? Though that's fundamental. Okay? So it's called a UAD, under agreement, dated. A UAD. Make sure that we understand what that is. A UAD, under agreement, dated. Okay? The date the agreement originated. All right? Now, another thing that that's inside the attachments would be appointment of trustee. That's very important. Okay? Who are the appointments? You got powers, but you need to appoint the trustees. That's a document that's in there. Okay? UDT is another important abbreviation, okay, which is under trust declaration. All right? So anytime that you're referring to the estate to the creditor, you would be under DT, under trust declaration, okay? The abbreviations again for trust is TR. The abbreviations for trustee is TTEE, which you will soon realize that when you go and get these EIN numbers, okay? Again, make sure that we are going through our state code on methods of creating a trust. That is very important. So methods of creating your trust, all right? Another thing is you can get into different kinds of trustees. I put in a lot of books inside of this folder for you guys because reading is fundamental. So even within your folder, there is a folder called trust books. Read them. You got business trust down here. You got common law, uniform probate code, pure common law trust. My favorite will be the Gilbert's Law Summary on Trust. That is the most in-depth book on trust that you're ever going to get. All right? So this is important. It takes about 30 minutes to create a trust. But it's going to take you about a year or two to learn how to operate in it, especially if you don't have some sort of guidance. If you don't have a guidance of someone that operates in trust and you're new to this, you know, you really have to get some understanding on how to operate because it's completely different. All right? When this video downloads, I'll put it inside of this Google Drive for you guys. So, and then when it uploads and I put it in there, no, I won't put it in there. I changed my mind. The only emails that are in this group are the only emails that can watch this video. No share. Sharing is not caring sometimes. Got to have standards. With that said, I'm going to open up the line so that we can have some questions from everybody. And then I'll check and see what's going on in the chat group while I was going along. So if you have any questions, feel free to step right up. Daniel, you said you have a question? Hello.
Hi. I am on the telephone line.
Okay.
So I don't have an email address that's showing up. So can I get access if I
you gave me your, who is
forward
it?
you an email? It happens to be Regina.
Okay, Regina. All right, Regina. I'll send it. You'll get the, if you're in here, you got the invitation. If you got the invitation to be up in here, you'll have the invitation to get the recording.
All right.
All right. Daniel, you said you had a question? I'm going to have to go from the bottom up and make it a lot easier on me. All right. Anybody else have any questions concerning anything that we're talking about as far as developing your trust, doing your will, doing your holding trust? Speak now. Ever hold your peace.
I would like to say thank you. This helped make it clearer to me how things are related to each other.
Well, thank you. I appreciate that. You know, it's all about just becoming the executor and the executrix of this estate, and then coming into your full faith and credit, and then being able to wash the hands of yourself and coming in perfect perfection. That's it.
Mm-hmm.
That is it, and that is all. And that is universal.
Hey, guys, if you're going to put your questions in the box, put your name in parentheses next to it so we'll know who we're talking to, okay? Go ahead and ask the questions. It's all right. Tiffany, don't bite. It ain't 11:30 yet. It's a lot of information, and you guys cannot know it all, so it is okay. There's no stupid questions.
No, it's not.
All right, so my thing, this is Stacy.
Hey, Stacy.
I was going to type it. So the registered mail, you said that makes a bond because the postmaster, it's cycled through, correct?
When you pay for an insurance, is nothing but bonds. Okay. Another thing to look into in your state code would be the section called insurance and bonds, or it could be bonds by itself. But all insurance are bonds.
Right. Okay.
Yes.
Okay.
Another thing would be, also guys, collect as many registered mail labels as you can. I would advise all of you to at least obtain, between 2 and 3 registered mail holding EINs, because there will be fellow sisters and brothers out there that is not awoke yet to know how important this is, and they won't even be able to attain these numbers if this government shutdowns again, which it doesn't bother me if it does, but it will bother them. Because if you cannot establish your will and your inter vivos trust, then all you have is the principal, is the birth certificate, and you have to go with a tribal society that is willing to accept you as a dependent.
Okay.
So let's make sure that we're getting that.
All right. So so 98 EINs, and are the 83 EINs for estates? Or
Yes, beloved. You would get your estate number. You can do that too. The way I feel about it, you can go either way, because in the eyes of a state, now that things are changing around, your EIN for your estate is your social. Right. Or you can convert it if you don't want to give out your Social Security in the public, which I would recommend to get that 83 number for the estate. And you can just do that simply on irs.gov, request EIN, and you can print off the confirmation there. All right? Yes. So what you would be doing is inputting that social and exchanging it for an 83 number.
Okay. Because I did get the 83 EIN, and I was just on that site just looking around, and I remember hearing about REMIC and all of that, so I've just been going back to that site looking.
Yeah, but they're connected. They're connected in the essence. I promote you to get that estate number so that you can stop circulating that social. Because another thing I want to share with you guys is that in order for you to completely expatriate and retire from your military occupation of the state, you have to prove that you have not been accepting privileges for at least 6 months. So in order for you to do that, you have to stop putting your social on certain things, because that is a Social Security account number. So by getting the estate number, the 83 number gives you a way to interface with the public without using that account, that Social Security account.
Awesome. Okay.
All right?
Yes.
Now be mindful. Now another thing I'm going to tell you guys is everything that you have your signature on, you need to convey into that inter vivos trust. You own nothing. You are the beneficiary, which is the true owner of the trust, but nothing is in your name. If you have a car, that car is in the name of the trust. And you are nothing but a Tesla. Your vehicle, well, not vehicle, your conveyance that you travel in is nothing but a Tesla made by Honda.
Right. So if I wanted to put, like, my brother in my trust, which, how would I go about doing that?
Well, I would put him in a holding trust. All right? So what you would do is you would just create him a will, because apparently you would have to be the trustee of that. So what I would do is create a will for him the same way you would do yours, and you would do a private security agreement between him and that holding trust. Basically, instead of how you conveyed all your property all your estate to the inter vivos, you would just put all of his estate into the holding trust.
Okay. All right. That's what I needed to know. That'll work. Because I know I've got them as far as like getting the wheel down, and I have been going through, like, I just wanted to make sure. So you did clear up a lot of things for me, so I do appreciate you.
Oh, thank you. I'm glad that I did. This is just very important. I wish that a lot of other organizations were teaching trust in estate law and civics, because I can't, a lot of us know what we're not supposed to be doing, but we don't know how to do what we are supposed to be doing. When a lot of things flip and change, I don't want any of y'all to be in a position of out there looking like zombies, because we have standard. And I'm going to let Taj come in and talk to you guys about having a standard, because if you're not standing for anything, why are you even here? If you don't have a standard of things that are what you're going for and what you're not, then you're going to fall for everything.
Yeah.
So there has to be a standard which creates covenant, which is trust. There are certain code of ethics and code of conduct that come with a culture of a people. There are certain things that you cannot do. You cannot do like the next man. You have to be different and set aside when you're in the private. And when you're in the private, you wouldn't be too much concerned with what's in the public, because you already know that that is all an illusion, a delusion. And you don't want no inclusion in that.
So yeah, hey guys, this is Taj. Like Tiffany was saying, we have a standard, and this has been something that Tiffany has been working on for a while, and it is finally coming to life. And we have quite a few members now, tribal members, and we're very proud of what we have going on at this point. And now the way things are going on in the public, we do have the right to be prejudiced. And I know it sounds jacked up, but we do, because we've worked very hard to come out of all of that nonsense and be into the land of private. And when you become private, you ain't worrying about calling yourself a Moor, a Hebrew Israelite, an Indian, African. None of that stuff matters, because at the end of the day, guys, if y'all really listening, when you step outside your doors and go into the public, all that matters in this game is if you're a creditor or debtor. That's it. Anything else is your personal business. Who you believe in is your personal business. You don't mix private and public. That's it.
That is the difference between racist and prejudice. You want to argue about racial groups, then you ain't filled out that SF-181, because that is the first point in you changing your status on a local level, is when you go to that SF-181 and that SS-5 and you correct your status from being a racial group to an original individual. And then when you establish that point, then you can no longer be included in racial groups as Moorish, as Israelites, as whatever, Nawapian, whatevers. You have to exclude yourself from racial activity. And now once you've excluded yourself from the public, and it's public, stateless corporations, now you can come in and be prejudiced and say, nope, I can't go for that. But what else were you saying, Tosh?
I bet you guys, you got more in common in the private with the KKK than any of these so-called conscious community groups out here leading you out over the cliff. Now hold that.
Okay, and another thing, guys, please don't say that you're an American Aboriginal national by way of a Hague Convention, by way of soil that is not on the North, Central, or South American land. Okay? You cannot be an American Aborigine national that has allodial indigenous titles to this soil if your ass says that you are from Europe or another continent. Because America is a continent. It's not a country. It's North, Central, and South. So if you were saying that you are off of that, then you're going to have to get off of that very soon.
Would that be like a place that started with the letter M?
Yes, Taj. Yes.
Yeah.
And end with the letter O?
I'm just saying.
Yes.
Now, this is when we get into the definition of state. Let me go back down there and pull that up again because we need some clarity. Spirit says take over. Now, check this out.
Claim more. I don't know when he started rocking with the Hebrew Israelites. So.
All right. State is. It doesn't matter how you see this. That's choice law. Okay. And inside of this trust, we operate inside of our tribal trust. We operate off of ecclesiastical tribal governance. Okay? That means that we have our own jurisdiction. And our boundaries go almost all the way up to Montreal and all the way down to the tip of Florida. I am that East Coast Empress. So, in any event, when we're looking at states, we have to know that we are private citizen of some state, rather it be your ecclesiastical Indian tribe, or it be the United States, which would be if you're Alabamian or Floridian, or if you are still a decedent estate out of the District of Columbia. Okay? So we have to know, and we also need to understand, family, and this is what I'm going to tell you guys going forward, because we have our own, this is a volunteered self-determination thing. All of us don't resonate with each other. There are multiple tribes out here for a reason. We all don't speak the same language. We all don't eat the same foods. We all don't dress the same, and that's completely fine. But make sure that when you identify yourselves that you stay within your standards so that people know exactly who you are. You have a unique identifying cultural imprint on this society. That means in order for you to have a unique identifying cultural imprint, you cannot be blending in with everybody. Because if that was the case, what makes you who you are?
Mm-hmm.
Okay? So, your state, like in our tribe, their state is the Lamu Pisgah Choctaw tribe. And that is their state. That is their jurisdiction. We cannot be out here belligerent and being stateless beings if you do not have a society or a state that you belong to. Because when you're out there and you're standing on your square, which is your jurisdictions, does anybody know what those 4 jurisdictions are? It's personam jurisdiction, subject matter jurisdiction, venue jurisdiction, and territorial jurisdiction. So if you slip up in the public and lose one of them, you lost them all. So if you're not standing on your society's jurisdiction and your full faith and credit, and if you don't have a credible state, then what are you saying? Property cannot own property. You cannot be property of a de facto corporation, but say that you are set aside. It does not work that way. It will never work that way. And that's why in this movement, a lot of us have not made any progressive changes because people don't understand trust in estate law.
I ain't seen the motherfucker.
All right.
Lemonade now.
Tiffany,
Yes.
this is Ayosha.
Hey.
Hey, so when we get these EIN numbers, like tomorrow, after we get them, we have to send them off?
No, beloved. Well, no, you don't send anything off. The only things that you would be, no, that you don't send these off. The only things that you would be sending off would be those 88 series forms and those 1040s and those fiduciaries 456s. Now, the only tax forms that you would be clocking in would be those Form 56s. And Form 56s of the executor and the creditor need to be clocked in at your local IRS agent. Everything else is to be mailed. All right? And it is mailed, and it's on that breakdown form that I shared with you on the IRS correction, where it goes into whatever birth state your estate comes from. You either go into Utah or Ohio.
Okay. Thank you so much.
You're welcome. All right. If there's no more questions, I'll close out here. It's Shalom on the walk up. I hope everyone to have a beautiful, delicious
Excuse me, Tiffany.
your Sunday. Yes.
This is Ascertainable Chapter. I do have a question in regards to the name change. On that form, when we fill out the name change, does it have to be in the original name that's on your current birth certificate? Or would there be an opportunity to change your name to whatever name you want it to be?
Okay. There's 2 name changes in this process. Now, I'm giving out privileged information right here, but I'll give you some guidance. All right? That birth certificate is your estate. Now, if you change your name, you could be married. Okay, let's put it like this. Are you a grass widow or not?
Yes.
You are? Well, then you need to go back and get your maiden name. And if you don't want to take on a hyphenated name, like a L or something like that, then you change your name back to your maiden name, and you put it in syntax, meaning it'll be first name, hyphen, colon, last name. Okay? And it'll be upper lowercase, and that's how you would do that. Because if you change, the birth certificate should still be in your maiden name, right?
That's correct.
All right. Well, then you need to go back to what it says on that original security. And then once you are ready to leave out the system, then there is a private way of you changing your name. Because what you're doing in this process is you're going to be rescinding all of that. You're sending back the social. That's why you have a 98 number. You're sending back driver's license. You're sending back all privileges and rights that you got, and you're exchanging them for your liberties. And the only form of identification that you should have should be your tribal state ID and your American national passport. You should have no state IDs, no driver's license. That is it. So when you get to that point, then you can go through the Department of State Affidavit of Name Change to go with your American national passport, and that's when you take on your tribal name or your spiritual name, and you can change the whole appellation at that point. But until you go to the Treasury, beloved, do not abandon that estate, please. Because there's a lot of people out here with these organizations that have done that, and they have acquiesced. And what they've done is they've given away their whole estate to where they have no way of contracting. So what they do is they sell fragmented packages so that they can subvert their families because they abandon their entire estate. So you be wary of these people. And if you are planning, hold on one second. And if you are planning on going into tribal engagements, ask them to send you the coordinates of their territory. Ask them to send you their tribal trust that should be with the UN Department of Energy and Interior. And make sure that they have their Great Seal and that they can authenticate documents. These are things that all of you need to check the credibility of the people that you deal with. All right. That was it. Thank you so much. You're welcome.
This is Aldo. I had did a name change back in 2012, but I didn't change all in all the departments. I only did it at the IRS or the Social Security Administration. And I was able to get a driver's license when I was in Connecticut with the name change. But I've been using my given name ever since. So how does that work?
We'll talk about that in your class because the next class you're having on Thursday will be about the authentication and the name change. So we'll talk about that in the class then. But it's very simple what you do.
Okay, thank you.
No problem.
Tiffany.
Yes.
Hello.
Yes.
May I address the ladies real quick?
Please.
Sisters, raise your standard. Get your process together. Get everything together so when you raise your standard, these men will change. Wink, wink, hint, hint. Every man that you'll ever meet in your life all he ever does is try to win your affection to get to you. So once you raise your standard, he's going to automatically raise his standard. Don't be falling for the okie doke. Stop shacking up. Stop having kids out of wedlock. Make him come to you correctly. But you got to be standing in your power first. And that's all I got to say about that.
All right. Shalom to that. All right. If that is it and that is all, I will close it out, get this recording to you guys as soon as possible. All right.
Shalom, everybody.
Shalom.
Shalom. Blessings.
Peace and blessings.
Shalom.
No, I said